Over to you, ma'am.
Thank you so much, Manya. It's always wonderful to be a part of IPRS, courses and whatever organization, like little bit of IT knowledge that we are able to spread out through you, through your platform. It's wonderful. And thank you for that wonderful introduction as well. So I hope the session yesterday went well. That was pertaining to trademarks, I believe, right?
Yes, ma'am.
Oh, great. So today we're going to cover copyright laws in India, and just to give you a brief, overview, like
Ma'am,
copyright.
sorry to interrupt you. My name is Dr. C. Balakrishnan. Ma'am, why am this slide will be shared for yesterday class today and tomorrow?
Sorry, I couldn't understand your
Yeah.
question, please.
Hi. The recordings will be provided after 2-3 days. So don't worry about that. Thank you.
Thank you, ma'am. Thank
Okay. So I think let's just start with me sharing the presentation, and I'll walk you through the presentation that I've created for this particular session. Yeah. Yeah. Is the screen visible?
Yes, ma'am.
Okay, super. Okay. So yeah, just to give you the introduction about copyright. Now, copyright is again one of the intellectual property rights which grants exclusive right to any author or authorizes any person to act certain acts. Now, we will definitely explore what certain acts are permissible and what exactly is the right given to any author or any creator of any copyright. Before that, we're going to actually explore what are the different domains which Copyright Act 1957 actually covers. So as you can see, it covers original, literary, dramatic, musical, and artistic works, cinematographic film, and sound recordings. So when we talk about the scope of copyright, broadly, these are the three main categories where the copyright lies, right? So definitely explore later in the session what exactly is literary work, dramatic work, musical work, different kind of works that Copyright Act actually encompasses within the domain, right? So copyright okay. So copyright basically is basically a bundle of rights which basically includes right of reproduction, communication to the public, adaptation, and translation of the work. It encourages the authors, composers, artists, and designers to create original work by rewarding them with the exclusive rights for a limited period to exploit the work for monetary gains, which can be done through licensing also. Then copyright protection commences the movement of work that is created, and its registration is optional. It subsists for a term which includes lifetime of the author who has created the plus 60 years post his death. So, just to give you a broader understanding, the slight terms that have been used in this, just to clarify further. So, at the moment any work is created, that very moment there's this automatic right which is created that's called copyright, which means that as basic as even any photograph clicked by you, the minute you click and you capture a photograph, the photograph is in existence. From that very moment, you get copyright in it. Likewise, with respect to literary work, dramatic work, musical work, and other works that are listed above. So when the right is instantly created, the other question is, do we need registration or not? A lot of times, because a lot of people they are really not aware whether registration is important for copyright or not. We deal with this question whether we should go ahead and file copyright for copyright registration or not, and should we get a registration certificate for that or not? Now, though under the Act, registration is optional, because they already give you right as soon as any work is created, right? So which makes the registration optional. Now, if you come to the legal point of view of this entire act and the liberty and the kind of vast right which is given to any author or any person creating the work, uh, we as lawyers, we always recommend to go for registration, because a registration just makes your right more strong. It is a certificate you can show in order to get in the enforcement work a bit easier. So definitely, whenever there is a kind of a question with respect to that, there are definitely other factors which we will definitely would examine when it comes to whether you should go ahead and get the registration or not. But said that, mostly we recommend to get the registration so that you have a piece of document to show your rights, and you don't have to get into the field of digging in documentation and evidence to support your claim in case of any enforcement actions. Uh, in that side, basically. So that, keeping in mind, in general, if you don't have registration, you still have a copyright with you. And I've also clarified the term that it is still the lifetime of the author plus 60 years after the death of the author. So now, for copyright work to exist, what are the basically key areas that are there? The work must be original and in legible form, unlike cases like patent. Copyright protects the expression and not ideas. So it has to have some form in it, which I mentioned. Either it should be a written piece of some like work, which is on paper, some musical piece which is completed, or even if it is in process, it should have some tangible form. Uh, a photograph, artistic work, all of that basically, the work should be completed. That's the broader idea. So that's why the comparison is there. Unlike the case with patent, copyright protects the expression and not the ideas. Patent can also be achieved for something which is going to be done in future, any technology or any process which can be completed in future, and they're still working on it. Patent has the bandwidth to protect that, but when it comes to copyright, we need to have a work in place. There is a very clear-cut, I would say, not mentioned, but anti-mentioned, that copyright does not protect an idea, which means that there is no such category of work which protects future work or any idea that you might come across and which is not in existence, that cannot be protected under the Copyrights Act. Then copyright can be claimed either by the creator or the person who has inherited the rights of ownership from the original creator, or an agent which allows you to act on behalf of the creator. Now, it happens so that many a times big companies, or for that matter any individual, would hire any person to do a particular act or maybe create a particular work. So how does that work? Basically, then in that case, the second aspect of the rights that comes in, that is acquired rights in the sense of inherited rights, ownership from the original creator, which means that you hire someone to create a work for you. You then becomes the rightful owner of the work, right? The creator himself is definitely the first holder of the right. He himself has the right to claim, copyright on any work that has been created. But yes, through hiring of people also, the work that is created, the person who hires can claim ownership of the work, provided there are specific contracts and agreements in place. So definitely in cases where there is hired, for services, for creating something, be very mindful that it's important to cover both parties, with a strong contract to that effect, so that the flow of rights are clear when it comes to claiming the ownership on the copyrights. Okay, so now we move forward to protection of copyright laws. Like I mentioned, that copyright works in the following three categories under Section 13 of the Copyright Act: original, literary, dramatic, musical, artistic works, cinematographic films, and sound recording. Now, what are the key factors which are important to qualify copyright protection, especially under the Copyright Act 1957 in India? So Section 13(2) specifically mentions the subsistence of copyright, the qualifications which are attached to it. So work is first published in India. Now, just to give you a background with respect to the first point, the qualification is that, like most of you must be aware, for those who are not aware, intellectual property rights, copyrights, trademarks, they are all jurisdictional basis, which means that they are the protection which is granted is only limited to the territory, to a particular jurisdiction. So with that, keeping in mind that background, the work must be first published in India for it to have protection under the Copyright Act in India. Second, where say any work which was published outside India, the author at the date of publication will be the citizen of India. So in that case, that particular that work can be protected under the Copyright Act in India. If the publication was made after the author's death, the author must have been at the same time of his death a citizen of India. So this is another condition that is there. Then, in case of unpublished work, the author is on the date of making of the work a citizen of India, domiciled in India. Now, this is in case of the work which is not published in any commercial sense, or it's not available for public out there. So if the author is a citizen of India, then the work is protected under the Indian Copyright Act. Then in case of work of architecture, the work is located in India. So now with this background, we actually moved now to what exactly are the different types of works that are available. So literary work. What exactly is the definition of literary work under the Copyright Act 1957? So Section 2A of the Act defines literary work. Now, literary work includes computer programs, tables, compilations, including computer database. So this is broadly the definition of literary work. A literary work must be expressed in some material form, that is written or in some kind of form of notion or symbol. To secure copyright for a literary work, it is necessary that labor, skill, and capital should be expended sufficiently to impart to the product some quality or character which the raw materials did not possess, which differentiates the product or the finished work from the raw material. Which means that we see that when it comes to literary work, we may rely on some already available material in order to maybe form our own material. Happens a lot in the sense of any research paper. So we sort of refer to a lot of raw material which is mentioned out there, and basis the information that's available, we deduce something. We sort of add our angle to it, our understanding to it. So therefore, it's important, like I mentioned in the first line, that there has to be a labor, skill, and capital which is applied to any raw material to give it, your skills which are there, and completely change it into a different work other than which is already available. So that's why when it comes to literary work, it's important to differentiate between something which has been copy pasted from some place and a work which consists of something which is adding value to that particular literature or literary work available out there. So that's definitely kind of a thin line that we usually look into when we come to the enforcement of it. But yeah, in order to create that right, that skill and your inputs are definitely important. Then a literary work need not have any literary quality, in the sense that even so prose a work as an index of railway station or railway guide or a list of stock exchange quotation could also qualify a literary work. Thereafter, in determining whether a worker is entitled to copyright protection, a rough tactical test is usually applied. What is worth copying is prima facie worth protecting. Okay, so that's something that in various judgments, some that kind of tests have been developed. Then collective works such as compilation, yearbooks, encyclopedia, etc., and computer software and programs, and other literary works such as law reports, commentaries on statutes, historical work are granted protection as literary work. Then we come to other set of work, that is dramatic work. So Section 2H of the Copyright Act defines dramatic work as dramatic work includes any piece of recitation or choreographic work or entertainment in dango, the scenic arrangement of acting, form in which fixed in writing or otherwise, but does not include a cinematographic film per se. So we will definitely come to cinematographic films and the ingredients attached to it. But when it comes to dramatic work, it's basically to do with some kind of entertainment, some kind of scenic arrangements, choreographic work, in order to give it a flow which is not a dramatic work specifically. Sorry, not a cinematographic film specifically. Just to elaborate on this point further, copyright subsists in original dramatic work in its adaptation. All cinematographic film is not a dramatic work. The script, or the scenario offered by any cinematographic film is a dramatic work, hence can be protected. Now this can be a bit confusing, so let me just walk you guys through it again. That any copyright in original dramatic work actually subsists in the adaptation. So what happens is that all cinematographic films are not dramatic work, but all cinematographic films becomes dramatic work when a particular script or a scenario is taken, or a scenario is adapted there from the cinematographic film. So that's one aspect of it. Then adaptation in relation to dramatic work means the conversion of work into a dramatic work. Then the abridgment of work or any version of the work in which the story of action is conveyed wholly or mainly by means of pictures in the form of suitable for reproduction in the film or in a magazine, newspaper, or periodical. So that is broadly adaptation in relation to dramatic work would mean. Then just to give you an example, choreography being reproduced to writing, usually in the form of some notion or notes, comes under the copyright protection. So a description of any choreography or any arrangement or any scene becomes a part of the dramatic work, and hence it is protectable. Then we come to musical work. Now musical works are defined under section 2P. What exactly is musical work? Musical work means a work consisting of music and includes any graphical notation of such work, but does not include any words or any action intended to be sung or performed with the music. Now this would purely include your, like examples are orchestral work arranged for piano, or any any melody that is produced which is accompanied by, say, orchid for voice or an orchestra. In popular music, there are arrangements of original songs made in a suit, made to suit particular performance. So there's like piece pieces of different, musical instruments or particular language or version of the next. So each such adaptation or arrangement is lyrical work, provided there's sufficient element of intellectual creation. So again, copyright basically would include in basically something which is not having any lyrics, um, uh, only the graphical notations and music per se would qualify musical rights, musical works, right? If a musical arranger or so decorates, develops or transfers to a different medium, or otherwise changes the simple music of popular song so as to make his arrangement fall within the description of original work, such arrangement or adaptation is capable of attracting an independent copyright. So which means that even if there is some inspiration taken from any musical work that already exists, and the music composer is actually able to do some changes, develop that basic music into something new that can be basically uh, converted into and is capable of getting musical work to be protected under Copyright Act. Now we come to the artistic work. Section 2C of the Copyright Act basically defines the artistic work. Now, this is the most interesting works that we see out there, and by the definition we go. So, artistic work means a painting, a sculpture, a drawing, including diagram, maps, charts, or plan, an engraving or a photograph, whether or not such work possesses art quality, right? A work of architectural, any work of artistic craftsmanship. So this is a very broad category of work, which would include a painting, a sculpture, anything that you've drawn, sketched on your notebook, which is different and unique and has some quality, would qualify under artistic work. A photograph taken, like I gave the example at the outset, wherein whenever you even click a picture, you have the copyright to that picture, that photograph that you've taken. So that work basically falls under the artistic work. So copyright can be claimed only in the original artistic work, right? Which means that you cannot say that, say, if you take reference from a photograph and you click the same photograph, then you can't really claim copyright to it, right? So for it to be protected under the copyright, it has to be original artistic work, in the sense there has to be some vision attached to it, some of your skills attached to it in order to create that work, right? So a copyright can be claimed only in the original artistic work produced by a natural person by expenditure of his personal skill and labor. So broadly speaking, any work that comes into existence, which we have discussed, which is capable of protection under the Copyright Act, broadly requires some personal skill or labor to it, right? So that's kind of the key factor when it comes to each work that can be protected. So adaptation of artistic work means the conversion of the work into dramatic work by way of performance in public or otherwise. So another aspect that's there, that's basically adaptation in different types of works, right? So be it adaptation of musical work, adaptation of artistic work, adaptation of cinematographic films. So in case of artistic works, adaptation would mean simply conversion of the work, artistic work, into dramatic work, where you're expressing by way of acting or making some arrangements with respect to any visual, treat or something that can be qualified as adaptation of artistic work. So, say for example, as because there's a, say, painting of some painting, and which involves maybe some deities or some like figures. So converting that and enacting that art in public by way of using humans, by way of using actors will be dramatic work. So in other case, in the case of other works, to qualify for copyright protection, an artistic work must be original, that it must originate from the author. In respect of paintings, sculptures, drawings, engravings, or photographs, the work need not possess any artistic quality, but the author must be bestowed with skill, judgment, and effort upon the work, which means that there, in case of paintings, sculptures, drawings, engravings, or photographs, they may take some inspiration from the already existing work, but at the same time, there must be some skill, judgment, or effort put on the work, which kind of makes it unique, or which kind of makes it there's some value added to the work. So in those categories, those types of works are basically protected. So again, they test what kind of judgment or what kind of skill and is required. So the answer is basic, minimal. It need not be exact copy of the work that you're taking inspiration from, but yes, there has to be a basic sense of skill, judgment, and effort attached to the work that has come into existence. A poster used in advertisement is an artistic work. The written matter in advertisement may be considered as a literary work. So just to clarify, a photograph club with some description of the product will have these two different works attached to the same piece of work, like just a poster, which is a complete work. So it may have multiple works also attached to it. Get up, arrangement, and color scheme of a label used as a trademark or decoration of container of goods may constitute artistic work, artistic craftsmanship, and subject to copyright protection also. So any mascot used for, say, trademark as a trademark is capable of protection under the Copyright Act, because it encompasses some kind of say maybe a drawing or some different aspect, in the sense of like a diagram or anything, a symbol. They all, because they have been created, which falls under the category of artistic work, and therefore they are basically they have this protection under the Copyright Act. Now we come to cinematographic films. Now, cinematographic films are defined under Section 2F of the Copyright Act. So a cinematographic film means any work of visual recording that includes a sound recording accompanying such visual recording, and cinematograph shall be construed as include any work produced by any process analogous to cinematography, including video films. Now here, two major components of cinematograph film would include a visual recording clubbed with sound recording. So when any recording is done, which is also accompanied by sound recording, then that's nothing but a cinematographic film. This can be as basic as maybe combining a video with only a musical piece of instrument, right? So with the background music, a simple visual can also qualify as cinematographic film. It may include dialogues, it may include literary work. So cinematographic film is basically a compilation of various rights combined together. So just to further, a cinematographic film is a film which, by rapid projection through an apparatus called cinematograph, produces an illusion of motion on the screen of many photographs taken successfully over a long period. Now, this used to happen earlier, but now we have such advanced, technology that we really don't need to actually go through the process of creating illusion motion. But just to explain sense of it, how in earlier times cinematographic films were created, I included this aspect. Then there is no express stipulation under the Copyright Act that cinematographic films should be original, as in the category of literary, dramatic, musical, and artistic work. Now, this is pretty interesting because there is no such express requirement under the Act, which may suggest that a cinematographic film be original piece of work, like we have discussed in other forms of work. But copyright will not subsist in a cine film if a substantial part of it is an infringement of copyright in any other work, right? Which means if the substantial part of the film includes copy of a musical work or any literary work combined together, then in that case you can't claim, right, that because cinematographic film is a different product from these different rights, different works, and therefore you can claim that plea. No, if a substantial part is infringement of other, copyright of other works, then it will not have any copyright in it. It would therefore follow that the originality, the criteria is applicable to cinematographic films. So it the difference is now here the original work that subsists that necessarily is required to be be present in literary dramatic music work in any which way is applicable on cinematographic films also, to the extent that it is the underlying work. So cinematographic film has underlying work, say literary work, dramatic work, musical work. That work needs to be original too. Otherwise, it loses the originality and it may not qualify under the protection under the Copyright Act. So the actors and the opponents in the film are conferred special rights in the film called performers' right. Now that's a separate set of rights which are recognized by the Copyright Act 1957 under Section 38 of the Act. Cinematographic film is taken of a live performance like a sports event, or it may be based on cinematographic version of literary or dramatic work. In later case, if the corresponding literary and dramatic work is copyrighted, the making of the film will require the consent or license of the copyright owner in the literary and dramatic work, since such copyright includes the right to make a cinematographic films as well. So which means that just to cover up the earlier point 3, here, if in case you have taken due permission from the original owners of, say, literary or dramatic work, and you have the consent to use their work, then in that case, you will be protected under the Copyright Act. But the highlight of this particular point is that there must be some permission or consent or license that you have procured from the original copyright holder in case of literary and dramatic work. Now we come to sound recording. Sound recordings are defined under 2XX of the Copyright Act, which means sound recordings means a recording of sound from which such sound may be produced regardless of the medium on which such recording is made, or the method by which the sounds are produced. Yeah. So, just one, I'll also, yeah. So basically, this is recording of sounds which such sounds may produce regardless of the medium. Just one second. Yeah, I'm so sorry for breaking that. There was something that came up. Let me just quickly restart. Okay. So I'm just taking it a little back, just lost the thought. Okay, sound recording means a recording of sounds from which such sounds may be produced, regardless of medium on which such recording is made, or the method by which the sounds are produced. So copyright will subsist in the recording only if it is lawfully made. Um, if the recording includes material which is an infringement of literary work or dramatic work or musical work, command to copyright, then the copyright will not subsist in that particular sound recording. The copyright subsisting in the recording of music is separate from copyright in the music. Copyright is in the music vest with the composers actually, and the copyright of the music recorded vest with the producer. So now here two different, names are, the kind of representations are mentioned. One is composers, one is one is the producer. So what happens when a music is composed, right? Uh, there are musical notations, graphical notations, which are used in order to maybe put lyrics into motion, right? So that is the job of a composer. Whereas when a copyright is recorded, um, it vests with the producer. Why? Because producer is someone on whose request the sound recording is being created. So producer becomes the first owner also of any sound recording. Again, it's very important to have a proper agreement between a producer and a composer before any such agreement or any such work is being created. Um, then the publication of sound recording in respect of any work is prohibited unless the sound recording displays the following particulars. That is the email address of the person who has the recording, name and address of the owner of the copyright, and the year of first publication. So yes, just to broadly give you a gist, the rights under copyright law are primarily of three types. Now, once because we have the understanding of what kind of different work is protected under the Copyright Act, it's important to also evaluate what are the different rights which are created. So broadly, there are three types of rights which are created under the Copyright Act. One is the economic right, one is the moral right, and another one is the neighboring rights. So economic rights are defined under Section 14, moral rights under Section 57 of the Copyright Act, and neighboring rights are ranging between Section 37 to 30A. So economic, I will be just, I'm honestly a little low on time, so I will be just walking through the PPT a bit quick, and I can definitely share this presentation for your reading at a later stage. In case you have any doubts or questions, you can definitely get back to me. So economic rights are basically those rights which give you rights to reproduce, they give you rights to distribute, they give you rights to communicate work to the public. They give you right to make cinematographic films or sound recording in respect of the work. They give you right to make translation of the work. They give you right to make adaptations of the work. So broadly, these are the six rights which are covered under the economic rights. So when I say they give you right, they give you exclusive right? No other person can use your work and maybe reproduce it without your permission. They cannot just start distributing the work without your permission, right? So all these rights are basically rights which are used by the author or the creator of any copyright work in order to exploit the work that they have created exclusively by them, exclusively by the author of the work, which means that that's where monetization aspect also comes into picture. Say, for example, any music is uploaded and that music is is being watched by people. So all the royalty that is being collected goes back to the author unless and until there are different agreements or contracts, in order to have the monetization aspect clear, right? So by default, the author of any work will give you right to reproduce, distribution, communication to the public, and cinematographic work and other aspects of the copyright laws. Then moral rights are basically rights wherein even if you have given license to any person to may reproduce the work or to give any to maybe use it as an adaptation of any work. So moral rights basically are under the Copyright Act. Basically, is essential that the author is given due recognition. So say for example, if there is any adaptation of any book, by adaptation I mean say there is a movie or a cinematographic film which is created based on a book, the author, even if the rights or license is granted by the author, it's important that we disclose the name of the author, the name of the book. So these are certain moral rights. And in addition to that, another aspect of it is that the work that has been, say, given as a license or to use for adaptation is not distorted, is not altered, right? So these are certain rights of any author in which under the Copyright Act. Then neighboring rights are basically broadcasters' rights, which means that by communication to public specifically. These are certain ancillary rights which are granted by means of wireless diffusion, whether in or any one or more forms of signs, sounds, or visual images by wire. So basically, these are certain different rights, basically covering different media in which a work may be communicated to public. Then neighboring rights, apart from broadcasters' right, are also performers' right. So basically, performer is a person which may include any actor, singer, musician, dancer, acrobat, juggler, contour sneak, charmer, such person delivering a person delivering a lecture who makes a performance, right? So if I am reading a book, um, uh, you know, it becomes like a performer's right. So those are also rights which are a part of which are given under the Copyright Act to the author. A performer has the following rights in his performance: right to make a sound recording or visual recording of the performance, right to reproduce the sound recording or visual recording of the performance, right to broadcast the performance, and right to communicate the performance to the public other than by way of a broadcast. So this is another set of rights which subsist with the performer for about 50 years. Then the aspects of fair use and fair dealing. So this becomes kind of an exception to the entire scenario of the infringement aspect. So how do we deal with that? So here I am dealing with fair dealing. Just to give you a bit of background as to what exactly is fair use. Fair use is something that is used under the United States laws. US basically use the term fair use, whereas in India and most common law countries, the concept of fair dealing is incorporated in our legislation. So Section 52(1)(a) of the Copyright Act actually deals with fair dealing. So just to give you a very broad overview as to what exactly a fair dealing, uh, like as mentioned under Section 52, private or a personal use, including research. So if you have gotten some piece of research and you're using it in maybe your private life, or you're using or sort of dealing with that research on your day-to-day basis and not exploiting it for any commercials, that is fair dealing. Then criticism or review, whether of that work or other work, that will be a fair dealing. You're just reviewing the work. You're not again using that work for any monetary gain. Then reporting of current events like current affairs, including reporting of a lecture delivered in public. So all of that basically deals with fair dealing. Mm, Unlike fair use, only if such a dealing is permitted by the terms of the applicable copyright laws, fair dealing of a copyrighted work is not deemed as infringement. So these are the few examples that I gave, which will qualify as fair dealing, and therefore they will not constitute infringement. There's this judgment by the Kerala High Court, which clearly mentioned that it may be reasonable to hold that the reproduction of the whole or a substantial portion of it as such will not normally be permitted, and only extracts or quotation from the work will alone be permitted, even as fair dealing. So, which means that you cannot take a plea that the whole work is kind of reproduced and taking a plea of fair dealing. It may be very clear that maybe some parts or some quotations or some extracts from that work is taken, which may qualify as fair dealing. So there are certain factors which were laid down by the court, which would constitute fair dealing, and that is the quantum and value of the matter taken in relation to the comments or criticism, the purpose for which it is taken, and the likelihood of competition between the two works. So these are the factors which will help determine whether a particular use of the work was fair dealing or infringement. Then fair dealing again is not a license to violate any exclusive right of copyright owner, right? So there are a few judgments also I've mentioned with respect to the fair use. This again broadly defines the concept of fair use and fair dealing. Like I already mentioned that fair dealing is an exception to copyright infringement laid down in copyright statutes of common law jurisdictions such as UK, India, and Canada. Whereas fair use is a limitation to exclusive right in works of authorship granted under the US Copyright Act. So this is broadly the difference between the two. Then I would actually love to talk about this aspect also, but honestly, I'm really short on time, so I will have to close the session here. But I will be definitely sharing this presentation, which talks about an interesting overlap between the Copyright Act and the Designs Act. It also talks about overlap of copyright and trademarks, which I touched upon a bit earlier in this session. And just to conclude, the copyright protection is very strong and effective in India. However, we definitely see some gray areas around the copyright laws, which is not fully developed in certain aspects, in certain areas of the work that the world is actually witnessing now. And again, copyright laws are again very open-ended, which means that it's very important that you protect yourself, any work that has been created. You protect it by way of registration. You protect it by way of getting into strong contracts in case you are working for someone or if you're hiring someone. So those contractual bit must also be very, very strong when it comes to entering into any such work which is related to copyright. And like I mentioned, newer laws that particularly address and deal with the problems and challenges of today can be added to the old ones as a supplement. So definitely we are seeing a lot of innovation and different types of work getting developed. And in my opinion, there is kind of a need to sort of have that thing also reflected in our current laws. But overall, it definitely gives a very strong base work to the creators and authors of the work that we covered today. So on that note, I would like to conclude this, and I would just maybe take one or two questions because I'm really low on time, or maybe you can just put it in the chat box. That would be great. Over to you, Manya.
I think we have just one hand raised. We can take one question. I don't think we have any question in the chat box. So Vidya ma'am, please go ahead with your question. Are you there?
Yeah. Hi, ma'am. How are you?
Hi, very well.
Yeah.
How are you?
I'm good. I'm
Yeah.
doing good. Thank you so much. Ma'am, recently I'm a contract specialist and a client of mine who happens to do a lot of sketching professionally also, but that's not his main profession. So while he recently got a contract from a big hotel for sketching some tribal figures, 12 in number. And while drafting
For
the
catching, what exactly for catching? I couldn't
for
understand that part.
making sketch of some tribal
Making
figures
sketch.
and faces
Okay.
and all that. So
Okay.
while drafting the contract, ma'am, I had a not a doubt, but though I have a concept on that. But when it came to mentioning a point about the intellectual property, since it is
Yeah.
a contracted work that my
Yeah.
client has been contracted out, so
Yeah.
can he at a later point of time use it somewhere else?
Okay. So yeah, I mean, it's a great question, and I think it makes a lot of sense. What exactly are the commercial terms between the person who's giving the contractor and your client? So this
Yeah.
is an aspect which needs to be dealt more than legally, commercially. Whether the contractor would like to have the rights in that drawing or the sketches. Accordingly, we will have to make amendments to the contract and include that language. But in case your client wants to retain the rights and he's very sure that he wants to retain rights, then the contract can be amended to include a limited rights given to the contractor only vis-a-vis use in a particular way that he wants to utilize the work. So definitely the commercial aspect here will play an important role. Both can be worked out.
Okay, ma'am. That means if I'm in terms of IP section in the contract, if I can put 1, 2, 3, say 7.123, and differentiate the different rights that both the parties can have,
Yes,
so
yes.
that will be more convenient. And legally, if any issue pops up, then also we can be in a position to deal with it, right?
Yes. So it's important to have a clear, mention as to who is the owner of the work that has been created, acknowledgement of that work, the authorship in that work, and again giving limited rights to the contractor and retaining the rights that we discussed, like right to reproduce, right to distribute with the with your client basically. So that
Right. Thank you.
demarcation will help you in the contract
Yes,
and
clearly
actually to
stating.
enforce
Yeah,
it.
clear. Yes, yes.
Yes.
Thank you so much, ma'am. Thank you, Manya.
Okay.
Thank you,
Great.
ma'am. So let's conclude the session, ma'am. I would like to thank you for this informative session. I know that you are in a rush, so like you have a
Yeah.
meeting, an important meeting. So I'm all the best for
Yeah.
that. Thank you so much. Thank you so much,
Okay.
everyone, for joining in the session. See you all tomorrow. Bye. Signing off.
Thank you.